Hello, everyone, and welcome to today's webinar, the $100,000 update and alternative pathways for the H-1B. My name is Joshua Wallace. I'm the Vice President of Sales here at Joorney, and I will be your host for today's session. Let's wait a minute or so to give some people time to join. And while we're waiting, we love to say hello to everybody in the chat, so it's interactive. Please let us know where you're tuning in from today. We always love to see people all across the United States and from all over the world joining our webinars. All right, we've got people in New Jersey to San Francisco. We're going coast to coast from Pittsburgh to San Diego. Amazing. Houston, Texas, Miami, Florida, India. Amazing. We have some international representation here. Thank you, everybody. All right, we'll wait just a few more seconds to get started. And yes, as Maya mentioned in the chat, so great to see so many familiar names here. Thank you, everybody, for joining. And while we're waiting for a couple more people to join, I will just quickly introduce to you a little bit about Joorney for those who may not know us. Here at Joorney, we partner with immigration attorneys and their clients to create high-quality business plans and supporting documents for immigration petitions, empowering international entrepreneurs and professionals in their life-changing endeavors. We also provide case preparation services, supporting immigration attorneys by organizing client documents, drafting petition letters, and assembling complete, ready-to-file case packages. All right, let's get started. So as you've definitely seen in the news, there is a new potential requirement for H-1B petitions that was recently announced, a $100,000 fee. This announcement has already created significant uncertainty for both employers and foreign workers, leaving many attorneys and their clients searching for clarity and alternatives, which brings us to today's session. And to guide us through the implications of this potential policy shift, I am joined by Toni Xu, immigration lawyer and founder of Xu Law Group. Toni brings a wealth of experience advising clients through complex employment-based immigration matters, and today she will share her insights on what this change means, how it may reshape demand for H-1Bs, and which alternative visa pathways attorneys should be considering right now. Hello, Toni. Thank you so much for being with us.
Hello, Josh. Hi, everyone. It's great to be here.
All right, everyone, and just a quick note, if you have questions during the session, please use the questions tab on the right side of your screen, and we will hopefully have time to answer some of them at the end. And with that, let's get started. So Toni, can you please explain in as simple terms as possible what exactly this new potential $100,000 H-1B fee entails?
All right. Okay, where do I start? Well, it all started on September 19th. I think it was towards the end of the day. A presidential proclamation dropped. The topic was restriction on entry of certain non-immigrant workers. And this immediately sent a lot of people, including attorneys, employers, and of course, H-1B workers into a scramble. If you read the text closely, at the time it had a few broad parts, and the most prominent one was a $100,000 fee was dropped to employers and to restrict the entry of certain non-immigrants and specifically the H-1B workers. And it became clear that the president was invoking his power under INA 212F to restrict the entry of certain aliens into the country. The proclamation was phrased in vague terms that left a lot of questions unanswered. So I remember it was a Friday evening and I was just about to get out of work. And I noticed this proclamation dropping. So I posted a LinkedIn post, and immediately I had something like 100 people reach out to me asking, am I being affected? And other attorneys as well posting about this, and many of us reached the conclusion. Um, so far we don't know a lot of things. It leaves a lot of questions unanswered. Well, fast forward a couple days. It turns out that CBP, DHS, as well as the State Department had all issued their own interpretations of this rule in the following days, on a Saturday and a Sunday. Um, all of this was immediately after the proclamation being issued, and right before it was about to take effect, which is on a Sunday at midnight. So you can imagine the chaos, what everyone was facing. What was concerning was that the CBP and USCIS, or DHS, and Department of State all seemed to disagree with each other in the interpretation of this proclamation. The CBP specifically mentioned that this would only apply to new petitions filed after the deadline for beneficiaries that are situated abroad, right? So that seems to imply that anyone who is already here, even if you're an F1 student or an OPT student who are going to enroll in the lottery in the fiscal year 2027 H-1B cycle, you would not be affected. However, the interpretations by DHS and by the State Department issued a FAQ session, FAQ publication. They were much more restrictive when it comes to interpreting this rule. Specifically, it sounded like USCIS would apply the fee to all the new petitions, right, in their directory, in their directive, and the State Department would left it ambiguous whether it also applied to all the petitions abroad or only petitions in the U.S. Right? This issue remains unresolved now until not until, but and a few days later, I think it was October 3rd, there is now a litigation that's filed by a group of plaintiffs that are affected by this proclamation in the Northern District of California, and in that litigation, something called a vacatur was sought, which, if granted by the federal judge, would set aside and declare unlawful this proclamation, or the 100,000 fees imposed on the employers. And that's so far what we know about this. A lot of things are in the air, but what we do know is that this administration has used social media to clarify their rulemaking, which I guess we shouldn't be surprised about. And in various inconsistent social media posts, as well as the various agencies' interpretations of the proclamation, we can glimpse what is actually happening. And that does seem to be like, if you have an existing visa that were previously approved, then your change of status, your transfer, and your extension would not be affected by this proclamation. That means that the employer would not have to pay the $100,000 fee. However, does that mean that if you are sponsoring somebody who is already here on another visa, then you're safe from the $100,000 fee? I'm not sure I can say with a certainty that's a yes, given the existing interpretations. So that's what we're left with right now.
Amazing. Thank you for that great recap, Toni. And we certainly all remember that Friday. I remember internally here at Joorney, we were messaging each other. LinkedIn is going crazy. What the heck is going on? Before we actually found out some information. You touched on this a little bit already, but can you mention, do we know, will this fee apply to all new petitions? Might we see any exemptions, maybe a cap exemptions for nonprofits, universities, hospitals? Has there been any information there?
There is no categorical exemption that was in this rule. However, there was language in this proclamation that left space for the DHS to decide per their discretion. If the application for the H-1B visa was in the interest of the nation and doesn't pose threat to national security. right? So that's a little bit concerning because we don't know how that exception or how that carve out of national interest will actually be carried out. There's no procedures or no criteria that were published. So that's still very much in the air right now.
And it was mentioned, I believe, that the fee should only apply to new cases. Again, as you mentioned, we're not 100% certain.
Mm.
But do we have any information about maybe transfers, job changes, location changes, visa extensions? Any clarity there as of yet?
Mhm. Well, I have filed a case after the proclamation, and that case got approved. So that
Okay.
was a transfer of employment petition. And I did notice a few other attorneys had been mentioning that their cases that were filed after 21st was received normal USCIS receipts without the additional 100,000 fees being asked for either upfront or in an RFE. So as far as we are now, it seemed like transfers and extensions and what is another one? Amendments. They're still going through. Um, but we have limited data because guess what? On October 1st, the government shut down and we can no longer file LCAs under the DOL. And if you go to the DOL flag system right now, it says, oops, under maintenance. So that's just adds another dimension to this.
Absolutely, and I'm glad you brought that up. This is certainly topical as everything is changing day to day, minute to minute. Do you anticipate any exceptions carved out should the $100,000 fee stick, maybe for healthcare, universities, nonprofits, any certain professions you think we might anticipate there is an exemption for?
It's hard to anticipate whether there will be exemptions for. So I cannot speak to that right now. However, I can provide some background.
Please.
I do think that this rule disproportionately affects smaller employers and hospitals or nonprofits or higher institutions, especially small employers, precisely because these employers don't have the resources to pay for the $100,000 fee. And just the sound of it will deter them from hiring a student who's looking for sponsorship under H-1B. And so, in that sense, it is already affecting them. I've talked to a few of my clients who are very concerned about this rule. And given the uncertainty, guess what? They're going to opt for not hiring anyone who could cost them $100,000 per case. Now, the litigation that's ongoing at the Northern District of California right now, there are plaintiffs who are specifically like religious organizations. I think the Nursing Association is a plaintiff in that lawsuit, and depending on the outcome of that case, I think we could potentially see some movement at DHS that could issue new policies, but I really don't know that right now.
And just tying into what you just mentioned, can you just touch for a second, Tony, on how, if the fee does go into place without any exemptions that we know of, how it could disproportionately affect certain sectors or certain people? I know yesterday we saw in the news a large company mentioned that they would happily pay the $100,000 fee. Of course, we're going to see smaller areas that won't be able to afford it. If you could just talk about the different types of companies from big to small that do file for H-1B and how this could have an effect on them.
Yeah. Okay. So in the proclamation, there was language that mentioned that the Secretary of DHS could exempt a company or a specific industry or an individual from this fee, right? So it is possible that if there was anyone who had the power to request an exemption, I think bigger company would have more resources than that than smaller companies. So in that sense, it's more likely that they're going to get the exemption. Now, I do think that smaller businesses, just given from the few of my clients that I've talked to already, whenever there is noise like this, whenever there is uncertainty like this, just simply not going to even invest in the possibility, even if this looks more favorable in a few months. I think they've already made the decision that they're not going to sponsor any new H-1Bs.
Great, great. No, thank you for that. And then jumping a little bit into alternatives, just slightly shifting our focus since, as we've been discussing, there are a lot of people, if this does come into play, might not have H-1B as an option, especially for those smaller companies that wouldn't be able to afford it. What alternatives do we know about? How could attorneys highlight these alternatives to any potential clients, and what kind of factors would shape those choices on which other visa type to go forward with?
Yeah, so there are a number of different alternatives available to employers. Um, there are short-term visas, and typically for an employer, they're more concerned about the short-term non-immigrant visas. These are the O1 visas, the L1 visas, the E2 visas, and potentially J1 visa for selected beneficiaries. Um, and for long-term options, there are the EB2, EB3, and EB1 categories that are very often used by employers. However, these are much longer term, and typically you would apply for you would apply for an EB2 or EB3 for somebody who's already here in the U.S., right? For example, on an H-1B visa. If they're abroad, the time horizon is simply too long for the employer to effectively take advantage of the foreign talent immediately.
Absolutely, absolutely. For some of these smaller companies who may be startups, for example, how could they look into leveraging options like the O1 or the E2 when they might have less resources than a larger company who could just pay the H-1B fee?
Yeah, absolutely. So I'm seeing more and more OPT, foreign students who are on OPT looking into O1, right? In recent months, increasingly more of them who are not yet graduated even are looking into O1 because they know that something is coming for H1B. And the thing about the O1 is that it has a much higher bar compared to the H1B. Well, the bars are different, right? H1B, there's a prevailing wage requirement. O1, there isn't, but there are depending on whether it's O1A or O1B, 6 to 8 criteria that you do have to qualify for. And those are not meant for the average Joe. Those are criteria that are designed to attract the most extraordinary talents with the best potential. So not everyone is going to qualify. And in fact, more than half of the people are not going to qualify. Now, the E2 visa category is for somebody who to invest in a entity in the U.S. And part of that investment is that it has to be bona fide. And the bona fide investment just means that you have to already spend the money, spend the investment. And in order for it to work, I've seen different interpretation on this, but you'd have to put some money into the company upfront and spend it, right? It could be something around 100K, in some cases even 50K. But for a student or for somebody who's just graduating to cough up that much money is difficult. Not to mention the obvious flaw in this visa is that it's only available to treaty countries. 70% of the H-1Bs are filed by Indians. These workers would not be able to take advantage of the E-2 visa.
So if a client came to you and the H-1B wasn't feasible because of potential economic limitations should the fee come into place, what kind of determinants would you look at as to which alternative visa to pivot them to, whether it might be an O1, an EB1, EB2 NIW? You just mentioned E2 also could have some financial limitations. But yeah, how would you go about looking at a client and their profile and whether they could pivot to an O or an EB1 or EB2?
Yeah. That's a very large topic. I evaluate a lot of O1s on a daily basis, and everyone's case is a little different. The way I like to do it is I like to group them into archetypes. So researchers would have a specific type of O1 profile, right? Then in that case, I would look for if they have published papers, what kind of journals, what kind of conferences do they publish on? Do they look like credible experiences? Because the O1 and EB1 game is getting pretty crazy nowadays, right? Lots of people are trying to get in, and not everyone's experiences are qualified, even if they look like they do. And for other archetypes of O1 visas, for example, a startup founder, the criteria are typically very different, right? So there, it's more about whether they have accomplished a lot using their startup, whether they have enjoyed high pay, whether they had investments, if they had prestigious memberships. I would say that practitioners who are not used to the O1 criteria now should look into it, because it's such a higher bar. I find that my role when advising clients on O1 is more of a strategic preparation role, less than filing the case and making sure that the company, like how many people that they want to sponsor under the H-1B. So the role of the practitioner also shifts a little bit here. Yeah, for something like L1 visa or the E2 visa, when evaluating these type of cases, it's more about understanding the company's business structure, right? For L1 visa, do you have a parent company abroad or affiliate or subsidiary? And has this talent been working there for a whole year, right? One full year in the past 3 years? And that's a very different conversation. That's a very different kind of evaluation compared to H-1B. Similarly for E2, it's more about what this company, like this petitioning company, will do in the future, and you have to make a solid business plan. Like Joorney here makes solid business plans, and you have to basically convince the government that this business that has just come into existence is somehow going to hire U.S. workers and succeed in the next 5 years. So I do definitely think that more strategy is needed for these complex type of immigration cases or non-immigrant visa cases. And I do find my roles be quite different when I advise them.
And you mentioned looking at short-term versus long-term options.
Mhm.
Can you talk a little bit about how maybe you might have somebody who doesn't qualify in the moment for a longer-term visa, and that game you might play between trying to get them on a shorter-term visa and then transitioning them to a longer-term visa in the future?
Yeah, this is a very common discussion for all of the non-immigrant workers here in the U.S. The unspoken rule is that if you want to, if an employer is sponsoring an immigrant for a temporary visa, then there is expectation that eventually there might be an immigrant visa being sponsored, right? Especially for H-1B, which is dual intent. Now, I find myself typically having that conversation up front with the beneficiary first, right? It's the employer rarely reach out to me and then asked, how do I make a strategic plan to keep this person forever? Well, there are a few selected employers who are here like that. But most employers are concerned about like a cost issue. Like, how do I make sure that this is not a problem for me, that this worker can just work here for the next 3 to 6 years? And when do I need to pay next, right? Usually it's the person who's motivated to stay here, like a H-1B worker, that wants to proactively seek out counsel's help to plan out their future, right? Either they're qualified for EB2, EB2 NIW, or EB1A. And oftentimes this becomes a discussion of how soon can they be free, right? How soon can they leave the current employer and then do what they actually want to do? Or just have the job freedom to be able to choose, right? That's a very important thing for immigrant. Yeah. Does that answer your question, or am I deviating
No,
too much?
no, all of it's fantastic information. Just to get into a little bit deeper. So if you have someone interested in an H-1B, I know you touched on this previously, but can you talk about some more of the criteria that might make one of those individuals a strong candidate for O1 versus EB1, for example?
Okay. Yeah. So let's say, for example, someone who is a software engineer, right? Because a lot of the H-1Bs are IT related. Let's say that a H-1B engineer just has to be paid prevailing wage and has a bachelor's degree or equivalent in the field. And that's, am I missing something? I think that's pretty much it. There's some requirements for the employer, but like the wage and the degree is basically it, right? Now, O1 is much more complex. For a software engineer, you'd have to prove that you're a better engineer than the other engineers, right? If everyone has a bachelor's degree, then you're not special. So there are these specific criteria. One of the top ones that I see would be published papers, right? If you have a master's degree or a PhD and you have published papers, you probably have met this criteria, and then a just regular bachelor's degree engineer doesn't have, right? That's one way to distinguish yourself. You could also have much higher than average salaries. This happens a lot with bigger companies. Big tech companies usually pay really well. And if you reach a certain level, then you also can say, like, I'm a better engineer that way. There's also a critical role of at a distinguished company. So this is something that sort of requires you to have some years of experience, right? Because without work experience, nobody has critical role, or unless you're a CEO of a successful startup and then you started young. But most people have to climb the corporate ladder and then get to that level later during the later part of their career, which is why you see a lot of the EB1A applicants now, they've been on H-1B for 10 years, right? They had a priority day of 2015. Like, I had a client who's like that. And so I would say that if someone is just looking to apply for the O1 and qualify for the O1, they should study the criteria now. They should look at their profile and then decide, okay, is this something that's even worth pursuing, or is this something that is basically never going to happen, right? And from there, they can either build their profile, or they could at least orient themselves that way so they have a second backup option.
Great. No, thank you. Thank you for that. And then just talking about maybe startups or smaller companies as well, as opposed to maybe some of the larger IT or tech companies. Would there be the same opportunities for those individuals to look at the O1, or would you see any differences between a large company employees on H-1B versus smaller startups?
There is no real difference in terms of chance of getting it, but um, I do think that founders are disproportionately more likely to apply. Or maybe it's because of their personality, that they're founders in the first place. They're easier for them to try new things or try harder things, but also they don't have, traditionally, like as of maybe a year ago, they did not have another choice. So being on an O1 visa was one of the very few ways they can stay here. Now H-1B had been changed beginning of this year, end of last year, to also allow self petitions, right? Not self petition. That's not accurate. To allow a company that the beneficiary has started to sponsor, right? But H-1B is so uncertain now. So effectively, founders find themselves back again in the situation where O1 visa is one of the very few options they have to stay here and work on their startup.
And then as we're touching on founders, could we talk for a minute again? I know you mentioned this briefly before about an entrepreneur, a startup, or a founder maybe looking to do an E2 short term or an EB2 NIW if they do have national interest qualifications for a longer term visa option.
Mm-hmm. Okay, I have done a few cases with this exact pathway. Right. The thing is that E2 visa is good for 5 years typically, but then you have 2 years of valid period of stay. And the E2 visa is not a dual intent visa. It's not like H-1B. So typically the way it works is that you would have to get the E2 visa first, and you would have to apply for the EB2 NIW at any stage, usually after your company is established a bit and you can prove that your company can actually contribute to the national interest, that there is some national importance or substantial merit argument to it. To backtrack a little bit, the EB2 NIW national interest waiver category requires the applicant to establish that they are going to they're proposing some future endeavor that's going to be in the interest of the nation, right? Very much similar to the national interest language that we hear from the new proclamation, in fact. And I hope it doesn't turn into another mini NIW. But the EB2 NIW type of cases is also future forward, right? It's more looking into what you will do in the future, and in that sense, it has some similarity to E2 for the company, but the EB2 NIW's national importance bar is much higher. So effectively, if you're on an E2 visa and then you are looking to apply for NIW based on the performance or financial performance or like success of your company, it'd have to be pretty successful to be able to, for you to be able to argue that it is nationally important.
And of course, in this scenario, you'd also have to be a citizen of an E2 treaty country, right?
Yes, that is the bigger issue for Indians and Chinese, for example.
Yeah, absolutely. And can you maybe just touch on that distinction for those who might not know as much information about these visa types, treaty
Sure.
country taking those steps versus options for non-treaty country?
Right. So for treaty countries who are countries that have signed trade treaties with the US, these are the citizens of these countries can use a visa pathway called the E2 investor visa. And the some of the common suspects that are not treaty countries with the US are India and China, right? Two of the largest immigrant source countries for the US. Now, if you are not a citizen of a treaty country, therefore cannot take advantage of the E2 visa, I've found two of the most commonly used visa types, aside from H-1B, because that's what we're talking about today, would be O1 and L1, right? O1 for starting your own company, but proving that you met 3 minimum extraordinary ability criteria instead of investing that money upfront under the E2. And the L1 visa is not usually available to somebody who has graduated university here, is on an F1 student visa, because you would have to prove that you have worked for at least 1 full year overseas in the past 3 years, right? And guess what? In the past 3 years, you were here a student, so you don't qualify. Yeah, so in that case, only O1 is left, it would seem, for the short term.
Great. No, thank you. And that's, of course, an important distinction. Where is the client from? So, Toni, if these rules remain in place, whether it's short term or long term with these fees, how would you see the greater practice of H-1B law changing? Potentially more litigation, more advisory, more reliance on the visa categories. Yeah, I know it's a broad question, but if you can, give us an answer.
Yeah, I definitely see more litigation. In fact, I've tried to look into the future a bit to see how this would go based on past patterns. And litigation is definitely here to stay. And this is what I am following the most nowadays. What keeps me interested is the Northern District of California litigation, where the plaintiffs and the counsels representing the plaintiffs seek that the court issue a vacatur, which is a device that you can use, that the judge can use to basically declare the $100,000 fee unlawful and set it aside, right? So if that were to happen, then it would be fantastic, because it would be as if the judge said that the rule never existed, right? They just set it aside completely on a national level as well. However, the DOJ is not going to make it easy. Well, there's of course they're not going to make it easy. They're probably going to file an appeal in the Ninth Circuit, and even if the Ninth Circuit grants a stay of that, then they could still run to the Supreme Court and file an emergency stay. And what ends up happening is that we will not know whether this $100,000 rule is eventually going to be in effect or not, and when. And we're just going to have to keep following it, I guess, and following the litigation. And who knows how long this is going to take. So that's one of the things, like, we're going to have to really follow the court cases, because these type of rules, federal court cases, well, no longer for national injunction, but for vacatures, et cetera, that still could affect all the clients nationally, right? Number two of the things that I think will change for the practice of immigration law is that we're going to have to orient ourselves more as a strategic advisor. If H-1B were to, not be used as much by employers because they're scared of uncertainty, then they would have to switch to more complex options like O1 or E2. And I would say that consulting these type of visas take at least probably 5 times more upfront time for me to explain to the clients whether they qualify and how they know they qualify and what they should do compared to an H-1B case, which is fairly straightforward, right? So our roles would just be completely different.
And that's a super, super interesting point you bring up, Tony, how it will change your job and other attorneys' jobs should you
Yeah.
have to discuss these alternative options to clients. That's great advice. And of course, being a little bit live and interactive here, I'm seeing a couple good questions in our chat. Obviously, you don't have a crystal ball, Tony, but the lawsuit, how long could that take? One of the questions that was just posed was, any idea how long it might take to see some developments in the lawsuit challenging the fee? Do we have
Yeah.
any proposed timelines? Could it be months, years? What do you think?
I don't know, but if history was an example, and I've seen other news about this, is that we should expect a lot of movements in courts and federal courts towards the end of this year, at least for the Northern District of California case. I think that some sort of order of whether granting the vacatur or not would be issued. And then it would be challenged immediately, maybe in a matter of days.
And in the meantime, do you foresee some of the larger companies paying the fees or kind of doing a more wait and see approach to the litigation?
Yeah. Well, some of them had already mentioned, like, right, you just mentioned, Josh, that they're willing to pay the fee. But you know what? There's no way to pay the fee right now. That payment mechanism is not out. Nobody knows how to pay this fee, even if we wanted to. I have not received. Oh, I don't know if any attorneys. If you have received a request for the $100,000 fee, please let us know. Like, I do not know what it looks like, and there's no payment portals for it. The USCIS online fee guide does not include 100,000 fees. I do think that there is a lot of chaos when it comes to this proclamation. And the aftermath of how different agencies disagreeing with each other very much suggests there's no interagency cooperation, and that that it was hastily drafted and not super well as well.
Absolutely, absolutely. And then another question that makes a lot of sense with what we're talking about. Your thoughts on potential backlogs for other visa types if all these H-1B potentials start applying to EB-1s, EB-2s, etc. How might that affect those being taken care of with the backlogs?
It's funny you mentioned that because I was just reading a post earlier today how there's like a picture of all of the paper boxes outside of the Department of Homeland Security of cases that are not yet been opened. I think it was like a front log counter. I think it was something like 60,000 still, like cases that are still not opened. Well, I mentioned this because something that you said about how this might affect the wait line for the other categories, visa categories, I do think is definitely going to affect it, because at the end of the day, there are a limited number of human officers that have to go through these cases. And per case, an O1 case and an L1 case takes longer to adjudicate. It's just, there's no question about it. Like the longest one, I'm not even going to mention how the longest of the O1 petitions look, but they are much, much more complex, right? And if all of your H-1B workers switch to something more complex like O1, it would take significantly longer for the officer to adjudicate them. And adjudicating them is hard, because these are complex criteria that they would have to actually interpret. And so I guess the quality of adjudication would also go down. Yeah, that's definitely going to be causing everything to take longer.
We had a question as well just about the basic processing times in the last year for H-1Bs, if you can just comment on how long you're seeing for those.
Okay, so for H-1B, you can either do premium processing or you could do regular processing. Premium is 15 business days. Most of the time is honored. I've seen that all of the cases that I filed recently in the past year, if it was premium processing, 15 business days, no issue. But if you file regular processing, I've noticed that it's right now taking something like 8 to 10 months. I have had a client who filed in February and they're still waiting for the regular result for their H-1B transfer. I know a couple clients who got selected in fiscal year 2026 lottery, so calendar year 2025, this year's lottery, and they're still waiting for their H-1B to be approved. They didn't want to file premium, but they're still waiting for it. So yeah, it's taking definitely a bit longer than before.
Great, thank you for that, Toni. And we've got about 15 or 20 minutes left, so I'm going to jump to some of the questions to make sure we have enough time to answer a few of those. So to anybody watching, if you do want to ask anything for Toni, please feel free to type it into the Q&A. One of the questions, Toni, is do we have any idea if this will have an effect on cap exempt cases?
So far, there's no language in the proclamation or any of the agency interpretations that exempt cap exempt institutions from the $100,000 fee. So my guess right now is no, there is no exception for them. However, remember we did mention that there was a sort of like a carve out exception that is up to the discretion of the Secretary of DHS, and that is if you can argue, you know, what if you can prove, if you can argue what you do is in the interest of the nation and does not affect national security, then you may be exempt from this rule. So it's by a case basis now under this proclamation. And that will be more selective and takes longer to adjudicate and possibly open to corruption. I don't know.
An interesting question here. Are you talking to any corporate clients that may be looking to alternative locations for some of their talent, potentially Canada or elsewhere?
Yes, I do know, unfortunately, employers that are switching to either set up a subsidiary abroad so they don't have to deal with this H-1B issue, or just offshoring the jobs altogether. So they're paying some contractors who never set foot in the US, which is exactly contrary to the national interest or the protection that this proclamation was set out to protect.
Absolutely. Absolutely. We've got a couple questions about which countries are filing for H-1Bs, which countries are getting those approvals. Would it make sense for there to be caps on any countries or companies? If you have an opinion there in general about who's applying for H-1B, where they're coming from, which companies are getting those people from those countries approved. Should we have any limits, do you think?
Yeah. Most of the majority of the H-1Bs are filed from India by Indian applicants, like applicants of Indian nationality. The second largest application pool would be the Chinese. They're Chinese applicants, I think it's not a close second. I think something around 70% and then 12%. Check my math on that, but that's about the breakdown that last I saw. 70% Indian and 12, something like 12% Chinese. Now I really want to know the exact number. And now the second question that you had, remind me what it was again.
I mean, just if you think there should be any caps or exemptions on certain countries, certain companies,
Hmm.
should we have a certain number that certain companies can have?
Yeah, right. Um, that is a very controversial question, right? Should I do I think there should be a quota per country? Well, look at what happens when there's a quota per country for the green card, right? And then you end up with people waiting a decade for it. And some of those are not less qualified than the others. So if you install a per country quota, you are turning it into a less merit based system, right? And that's the basis, or hopefully, I think it should be. merit should be the basis of these immigration categories.
Question about average approval times for O1 visas for somebody already in the United States. How quickly could those get done? Somebody on an H-1B or also maybe somebody on TPS.
Okay, I did a TPS 201 case a few weeks ago for somebody whose TPS was just about to expire because TPS for the country got canceled, got terminated, right? In that case, the timeline was very fast. We did it in under a week because there was no other choice, right? He wanted TPS here. There was no other way for him to. There's no way for him to go back to his home country. And nowadays, consulate third country stamping is gone. So if we don't do it in 5 days, he's basically gone forever. But I would say typically you should probably expect at least a month. So for us, it takes at least 4 months. At least 4 weeks for us to get a case ready, taking into consideration the time to really gather all of the achievements that you've amassed in your life, and also the time it takes for us to actually just craft the petition. I know that there are different timelines quoted by different companies. Some of those are AI startups that give you, a petition within 1 week or even within like 2 weeks, maybe a few days. I don't take that. I don't think that's a responsible timeline for a client. Now, if there's a true emergency, sure, but yeah, I think a month is very reasonable.
If more people are applying for other alternate visa types,
Mhm.
do you have any thoughts that maybe USCIS could raise the standards as a way to filter those increased filings?
They have raised their standards. I have noticed that they kept increasing their standards for the past 3.5 years. That yeah, and so the standards raising are a little bit subtle and slow. And the USCIS does publish policy manual updates. And then if you look at the history of policy manual updates, it did get harder over time. And there are some additional clarifications for the criteria. And there are new examples that are given for what count and what doesn't count. What I've noticed is that what used to count, for example, for O1 and EB1, certain memberships or certain judging opportunities or certain sources we use for proving like a website is a major media, those are increasingly not accepted by the agency anymore. And of course, there's also an increasing trend for inconsistencies and misinterpretations by the agency as well. And um, I don't think that's going to become easier all of a sudden. Yeah.
And
With
I think we
more
have,
applications.
oh, please.
Yeah,
Sorry.
especially with more applications coming, I think the standards would absolutely be higher.
Great. Interesting question here. Could some people, as a very short-term option, use like a B1, B2?
This has historically been used, but recall that B1, B2 visa is only for tourist purposes, for temporary stay visitor purposes. Um, on the B1, B2 visa, you cannot work. So that is one of the main restrictions.
Great. Then we've got some more specific type questions. So let's see if you have an idea. We might not. For new H-1B cases, if an applicant is selected in the lottery, do we know if the employer cannot then pay the fee, would they lose the chance to apply or file for the petition?
That's a very good specific question. I don't know. That is one of the questions that remain to be seen, right? Well, we can sort of guess what will happen based on past patterns. So in the past, without this 100,000 rules, if you got picked in the lottery and your employer says, well, sorry, don't want to apply for you anymore. We don't want to cough up $5,000 for your case. If you don't file before usually 60 days, is it 60 days or 90 days? Usually 60 days before the deadline of the H-1B filing to file the I-129, then you lose the opportunity. You lose this ticket. You have to use it this cycle, right? So I would say probably more than likely, if your employer just can't pay the fees, you would lose the chance for the lottery.
And based on the current proclamation or any information or interpretations, do we know whether the $100,000 fee would be upon initial application or upon winning the lottery? Has there been anything said to that effect?
No, there has been nothing said on this. The timing, how it's going to be collected, none of it is clear.
Any thoughts on your end as to whether they might try to do it up front or following a lottery?
Probably following the lottery. So upfront, a couple years ago, they changed the rules where you only pay the lottery fees. I think now it's raised to $150, and this is much less burden financially on an employer. So employers, I have noticed, are much more likely to sponsor if all they have to do upfront is pay $150, right? Now, but I could also see the other side. This rule is very much set in place to deter employers to hire a foreign worker, right? So the more effective way to deter them is to just charge this upfront. So I could see that. I could see that too.
Absolutely. And then we got a couple of questions about like change of employer petitions, if it might affect them, if people are abroad versus in the United States. If you could just touch broadly with your thoughts on that.
So right now, the standing interpretation of the 100,000 fee is that if you already have a issued visa, previously, let's say you got a H-1B stamp before, you want to change your status, you want to change employer, you want to extend it, getting a new visa stamp abroad won't mean that you have to pay 100,000. Well, the employer has to pay 100,000, right? So far, that's the practical interpretation, and I myself share with a lot of immigration attorneys, also consistent with what we're seeing. Yeah.
Great. And then a couple more questions here. Any suggestions on how people who might shift towards EB1A or EB2NIW or O1 can help build stronger academic profiles?
There are so many ways you can build stronger academic profiles or professional profiles. I won't be able to get to all of them. I would just leave them with this. Go to the USCIS website, go to the USCI policy manual, and then just read all the criteria, right? A lot of the information online you can find publicly are not accurate. The rules are published online. Just go read it first. That should serve as a very good basis for getting idea of what you qualify for and how, if you qualify for it at all. Now, of course, a lot of it is going to sound like gibberish. This is where lawyers would come in, right? A very good productive use of your time is to talk to an EB1 or EB2 NIW specialist to really understand how you qualify and how you don't qualify, so you can work on it or not. That's what I would advise them to do.
Great. Yeah, absolutely. And we've almost reached the end of our time, so I'm going to just ask you one more question. If you can, again, look into your crystal ball, Toni, and give an opinion on, will the fee end up sticking? What the outcome of the litigation might be? What are your final parting thoughts on how this will all play out and when we might see an end to it?
This is recorded, right? So I can,
Yes.
in the future, if I was wrong. Okay. All right. So disclaimers, I do not know the future. I think that this rule will probably partially stay. It will probably partially stay if it got to the Supreme Court, but at the appellate level, at the circuit level, I think that it's more likely it's more likely to go. Meaning, like, I don't think a Ninth Circuit judge will grant the stay to the vacater, right? Yeah, that's as far as I can see into the future.
Sure, absolutely. And it'll be interesting to see how this plays out. And yeah, just with the minute or two we have left, Toni, any parting thoughts? H-1B thoughts, alternative pathway thoughts, best practice thoughts, any advice for applicants and attorneys before we wrap things up?
Yeah, for applicants and attorneys, I would say plan proactively. Our practice is about to change a lot. And I think many of us, and I've talked to a few immigration attorneys too, they find themselves more stressed and they find themselves, I find myself looking to more of a strategic role, strategic advisor role, rather than somebody who just takes a job and finishes it, right? There's a lot of uncertainty. I find myself counseling my clients psychologically as well, even though I'm not a licensed psychologist and am no way qualified to do that. A lot of emotional intelligence is needed in this type of uncertainty. You have to really balance giving the best advice and making sure that the client understands what they need to do, and then does it, right, without being incorrect. And that's hard in times of uncertainty.
Absolutely, absolutely. And that's a nice way to end our session. There's definitely a lot of uncertainty, but as an immigration community, we certainly all come together to get the best responses we can and the best information and move forward to assist our clients as best as possible. Yeah, if anybody would like to reach out to Toni after the session, we've provided her contact information in the chat, her website, and an email address. Please feel free to let her know if you have any questions and want to reach out to her. And from us here at Joorney as well, you can find us on our webpage. We put some information in the chat if there's anything that we can assist anybody with. Thank you so much, Toni, for your time and fantastic information. That was a lot of fun, and we look forward to seeing you again.
Thank you. Bye, everyone.
Great. Thanks, everyone.